The vast majority of people will never find out about this until the moment has already slipped past them. Not because the information is concealed somewhere, not because it is impossible to comprehend, but because the sorts of changes that silently reshape millions of existences seldom become trending topics online or make it onto breaking news segments. They take shape inside courtrooms, expressed through legal phrasing that most individuals never care to examine. And by the point the ordinary American recognizes that something has transformed, the monetary consequences are already unfolding. That is exactly what has just taken place. The Supreme Court of the United States has rendered a unanimous 9-0 verdict. Every single justice, from the most right-leaning to the most left-leaning, came to the very same determination. And what they decided has forever changed how retirement operates throughout the entire nation. Not temporarily, not within a single state, not for a specific category, but forever, and across all jurisdictions. If you hold a pension, put money into a 401k, collect Social Security, or have at any point created financial strategies assuming retirement regulations would stay intact when you required them, this verdict directly concerns you. The reason this carries such urgency right now before the coverage fully emerges is that the shield it establishes does not automatically extend itself to your circumstances. You have to comprehend it first. A Supreme Court verdict is only beneficial to those who recognize how to apply it. So let us examine what truly occurred, why 9 justices who seldom find agreement discovered shared reasoning here, and why legal analysts are already characterizing this as one of the most significant retirement verdicts in the previous 5 decades. Before we proceed, you need to recognize what was genuinely at risk because this case did not originate as a watershed moment. It began with a single person refusing to concede that the government could rewrite the terms after the contest had already been completed. Envision committing 30 years of your existence based on specific assurances. Not informal assurances, but legally binding ones. Assurances inscribed into policy, integrated into the retirement framework you funded with every single paycheck year after year. You shaped life choices around those commitments. You selected a career in government service because the pension calculation made it rewarding. You remained in a state you might have otherwise departed because its retirement tax framework bolstered your financial outlook. You organized your savings, your retirement timeline, your investment portfolio, all constructed upon a framework the government itself created and urged you to have faith in. Then one morning, without seeking your opinion, without obtaining your permission, and without weighing the decades of preparation you had already finished, the government rewrote the terms. Not merely for upcoming participants, but retroactively for individuals already profoundly committed to the framework. Individuals who practically had no opportunity to begin fresh. That is what occurred to the retiree at the heart of this litigation. And that is what the Supreme Court was called upon to assess. The inquiry was not whether governments can revise statutes. They absolutely can. It was not whether retirement frameworks can be restructured. They certainly can. The actual inquiry was considerably more targeted and far more consequential. Can a government modify retirement regulations in a fashion that directly damages individuals who built their complete financial existence around the earlier framework? The unanimous response from every 9 justices was no, not unless the government satisfies a remarkably elevated constitutional threshold. Not unless it can demonstrate the modification is warranted enough to supersede decades of genuine life preparation constructed on the original statute. To appreciate why this holds such tremendous significance, you need to grasp the central legal doctrine at the core of the litigation. The justices concentrated on a concept identified as reliance. It is a legal term, but the underlying notion is uncomplicated. When you make substantial life choices grounded in a current regulation, when you dedicate years and resources into a framework because of how it functions, you are depending on that framework. And when the government establishes a framework expressly crafted to influence long-term conduct, promoting saving and preparation decades into the future, it cannot subsequently dismantle that foundation without being held answerable. That is what reliance signifies. And what the Supreme Court has now proclaimed unanimously is that retirement preparation is one of the most compelling illustrations of reliance in American jurisprudence. Retirement is not a brief term selection. It is not something individuals effortlessly recalibrate every handful of years. It is a lifetime dedication constructed on the presumption that the regulations will stay sufficiently consistent for the strategy to succeed. Prior to this verdict, states possessed extensive authority to alter retirement-related statutes. They could revise pension calculations, impose fresh taxes on retirement earnings, or elevate the threshold for complete benefits. They frequently defended these measures by contending that governments require adaptability to oversee budgets and react to economic realities. At first glance, that reasoning appears logical, but it disregarded something fundamental: the actual human beings impacted by those modifications. The educator who devoted decades inside a classroom because the pension rendered a modest salary acceptable. The firefighter who persisted in a physically grueling profession because retirement compensation made it financially viable. The retiree who uprooted across the nation for tax advantages only to witness those advantages vanish shortly afterward. These are not theoretical situations. These are genuine existences. What the Supreme Court has now established is that those choices, those years of preparation, and that dependence on government-established frameworks merit constitutional shelter. This is the juncture where the verdict becomes authentically revolutionary. The court did not merely declare that reliance carries weight, it formulated a three-part constitutional examination that states must now fulfill before modifying retirement statutes in ways that disadvantage individuals who depended on them. More critically, the court transferred the burden of proof. Previously, retirees bore the obligation to demonstrate that a policy modification was unjust, frequently demanding legal resources they simply did not possess. The state maintained the upper hand. Now, the dynamic is inverted. The presumption originates in favor of the person. The state must establish that its modifications are warranted despite the dependent citizens placed on the original regulations. This transfer is not trivial. In legal proceedings, whichever party shoulders the burden of proof frequently dictates the result. By assigning that obligation to the government, the court has fundamentally reshaped the equilibrium of authority. For the initial time, retirement choices made by millions of Americans are being acknowledged as constitutionally shielded reliance. Nevertheless, it is vital to remain grounded. This verdict does not permanently lock retirement statutes in position. States retain the ability to implement modifications. What has shifted is the benchmark they must achieve. The threshold is now considerably elevated. This is not an absolute promise. It is a protective mechanism, and like every protective mechanism, it only serves those who comprehend it. In the following portion, we concentrate on who gains the most. Public sector workers are the initial category directly affected. Educators, law enforcement officers, firefighters, healthcare professionals, and government employees throughout the nation. These people frequently accepted reduced compensation in return for dependable retirement provisions. When those provisions were subsequently diminished, it produced severe ramifications. This verdict now provides them with firmer legal footing to contest such modifications. The second category encompasses retirees who relocated based on state taxation policies. Numerous individuals moved during retirement to minimize taxes on earnings like pensions or Social Security. When states subsequently revise those policies, it can substantially affect their financial situation. Under this verdict, such choices may now be classified as shielded reliance. The third category is employed Americans still accumulating retirement savings. Those depositing into 401(k)s or IRAs grounded in present regulations are likewise safeguarded. Retirement preparation is a continuous endeavor, and every single contribution constitutes dependence on the framework operating at that moment. The three-part examination governs how the safeguard functions. First, did you make monetary choices grounded in existing regulations? Second, would the modification inflict genuine damage? Third, can the government defend that damage with a sufficiently compelling rationale? Only when every condition is satisfied can modifications proceed. So what measures should you pursue right now? Begin recording everything. Preserve documentation of tax policies, pension specifics, and account records. These could become essential proof. Consult with a financial professional who comprehends these developments. Examine your retirement strategies thoroughly. For public sector workers, compare your pension provisions against any recent modifications. This verdict illuminates a more profound reality. Retirement security has perpetually rested on trust, confidence that frameworks will stay dependable. For years, that confidence had no genuine enforcement mechanism. This ruling alters that reality. It proclaims that reliance is not simply a hope, but a constitutional concern. The narrative is merely getting started. States will react in varying fashions. Fresh legal confrontations will establish the boundaries of this verdict. But one reality is unmistakable. The period of silently modifying retirement regulations without repercussion has concluded. What you choose to do right now carries weight. Those who comprehend and respond to this will be better positioned. Understanding here is not merely influence, it is defense. Pass this along to anyone preparing for retirement because financial circumstances do not pause for awareness. The Supreme Court has declared its position unanimously. The communication is unambiguous. Retirement regulations can no longer be altered without responsibility. This is a long overdue transformation, and it belongs to every American who prepared, saved, and placed their confidence in the framework to